Hi, welcome back to HOA Hell. I'm your host, Michael Kushner. Today we're going to do something a little different. So far, each of the episodes we've done have been one-off episodes. They were discrete issues that I handled. And today we're going to start with something that I teased in our first episode, which is this is going to be one of our series episodes. I'm doing a 6-part series on HOA neighbor-to-neighbor disputes. Okay, these are basically all the things that can go wrong between neighbors. Because if you think about it, at least 50% of the cases that come into our law firm revolve in some way, at least, with a dispute with a neighbor. And they could be anything from a neighbor's, changing the grading and the water is leaking onto your, going into your foundation or causing water intrusion into your house, to a violent neighbor or a neighbor who has parties all the time, late into the night, or too much noise. They have hardwood floors and they aren't supposed to, and they're walking around and slamming doors, to root damage or leaf damage, or they're destroying your property. They're cutting down your trees, stuff like that. It's such a broad topic. I actually did a 20-page guide that is available free on our website at mbkchapman.com. You just go to the Learning tab and you can find it there. And I'll also include a link into the in the YouTube description and in the show notes in each one of these 6 episodes we're doing. But today's going to be episode 1 of that 6-part series on neighbor disputes. And today I have with me my usual co-host, Senior Associate at MBK Chapman, Sam Kill. Sam, hi.
Hello, Mike. Thanks for having me. This is a fantastic series. Very important, as you stated, some of the most common issues we encounter routinely on a daily basis. And I believe the folks out there will get a lot of good knowledge out of it, and looking forward to it.
Good. Well, today, episode 1 is going to focus on private nuisances, from noise to foul odors. And then, of course, each of the next 5 episodes of this series are going to cover different parts of what make up this broad category of neighbor disputes. So in this episode, we're going to learn about everyday problems regarding noise or odor. And I'm even going to touch on light pollution. Sam in particular has a case right now that dealt in part, we've addressed it, so that part's over, but it dealt in part with severe light pollution. And it's a timely, it happens all the time. And light pollution isn't just, they've got they leave their porch lights on all night. No, light pollution is somebody has a bright light kind of focused or shined in the direction of your house, or it's the wrong kind of light. And so it's so bright that it not only illuminates the neighbor's house or the neighbor's backyard, but also floods into your bedroom window at night, even with your blinds closed, that sort of thing. So we're going to touch on that today. And we're going to talk about the thresholds of what creates or what constitutes a private nuisance, what that is in the law, and then how to make that claim stick if you take it to court. Okay? If you can't resolve it before going to court, how do you make that claim stick? We're going to explain the critical differences between permanent and continuing nuisance, because private nuisance is broken up into those 2 categories. It's either permanent or it's continuing. So we'll discuss the differences and what your remedies are for each of those. So that's going to be for today's episode 1 of this 6-part series, Neighbor Disputes. So let's start with the obvious. What is a private nuisance? Okay, a private nuisance is, in very simple terms, when a neighbor is engaging in conduct that affects and this is an objective standard, that affects your ability to enjoy your property. In legalese, it interferes with your quiet enjoyment. You might hear that. It's the way lawyers talk, but really it interferes in an unreasonable way with you being able to enjoy your property. That's what quiet enjoyment means. Okay? Now, it doesn't have to involve actual damage, although that would be a nuisance. If somebody were to, if the neighbor's kid were to, take a paint can and tag your garage door, that would be vandalism, which is a crime, but it would also constitute a nuisance. Okay? And in that case, it would actually have real money damages. But it's anything like that. So it's a very broad category. That's what a private nuisance is. It doesn't have to involve trespassing, although trespassing it can also be alleged as a nuisance. So you'd have 2 separate claims because the same act can be 2 different wrongs. Okay? But it doesn't have to. So sometimes it has damages, sometimes it doesn't. Sometimes it involves trespass, sometimes it doesn't. Sometimes it involves a crime, sometimes it doesn't. So I hope you're getting the understanding that I'm trying to impart here is that when you talk about a private nuisance as a cause of action, it's a very broad term that could include a lot of different things that could also be crimes or cause damage or involve trespass or involve battery or assault, but they interfere with your ability to enjoy your home. That's all it takes. And there's two kinds of nuisances, private and public. We're only going to focus on private nuisances today, okay? Now, there's a civil code section, 3479, that defines the nuisance. So you can read that if you choose to. If you're one of those people that wants to do that, feel free. But broadly speaking, according to the statute, it's anything that's injurious to the health, and I'm just reading from the statute here, the health, injurious to health, that's indecent or offensive to the senses, and which obstructs the free use of your property. That is the statutory definition, but I've already told you the real world definition, which is it interferes with your quiet enjoyment, okay? But not everything would be a nuisance if it necessarily met one or two of those qualifications. There's elements that have to be met. And those elements, you can break them down into three, okay? Number one, the behavior in question has to cause a substantial interference, okay? It can't just be a minor interference. For example, somebody's being loud because they're having a party and they go late one night. Okay, so they go to midnight instead of 10 p.m. and you couldn't go to sleep and it was really annoying. If you tried to bring that as a claim for nuisance, you'd get laughed out of court, okay? Because it was a one-off. So it's not substantial, okay? It has to be serious. It has to be something that a reasonable person would consider seriously interfering with your quiet enjoyment, okay? If something happens every Saturday, was that enough to be a nuisance? It depends. It's a balancing act, okay? But a one-off, not going to do it. The second one is it has to be unreasonable. And unreasonable in this sense is an objective standard under the law. Subjective standard means, to me, in my opinion, it is unreasonable and therefore the law should see it that way. Now, some laws do have subjective standards, but this isn't one of them. Objective standard is what would a reasonable person in your position view this situation as? Would they view it as unreasonable? So this interference has to be unreasonable in addition to being substantial, okay? And it has to be objectively unreasonable. And the last one is causation. The behavior, the act that you're complaining of has to be the cause of your interference with your quiet enjoyment, all right? It can't be some distant cause that's, well, that caused that, which caused that, which caused that. It can't be that. It's got to be direct. For example, let's go to the tagging example. The kid next door tags on your garage, okay? There's a direct line between the interference with your enjoyment of your property and the actions of that kid, okay? He caused the interference by tagging. So direct line. So those are the three things you have to have. Did I miss anything?
No, just that in addition to the objective standards, obviously we get a lot of folks who are quickly labeled as being hypersensitive or, the inference there is that, it's a subjective standard. You're not meeting the elements under the objective
standard. We had one of those. We had a lady who had severe allergies.
Yeah.
And exactly. A very powerful, I think you call it a super smeller. She actually had training in the industry, which is maybe why she ended up where she did, but she actually worked for a wine company or vineyard, and her job is to smell wine.
Sommelier, maybe?
Well, I'm sure by training.
Or she was studying to become one,
I'm sure by education she is, but she works full-time for a vineyard, and her job is to smell wine. And she has what you would call a super smeller, okay? So, a very small percentage of us have maybe more of those cells in the nose that can pick up odors. But the fact is, she also happened to have allergies to certain normal, everyday kind of smells and chemicals, like the dyes, the smell of the dyes used in the washer pods and stuff like that. And she lived in a condominium that was a conversion from an apartment years ago. It became it was by the beach, beautiful area, but it used to be apartments. And so those aren't built to the same specs. And years ago, it was converted into condominiums and sold as private property. But I guess stuff was coming through vents, but her neighbor would use the Tide Pods at all hours of the day to wash her clothes. And this was causing a lot of problems for our client. And, unfortunately, the neighbor wasn't willing to cooperate. That was a tough issue because the standard there was completely subjective.
Right.
She did not have a nuisance claim there. Okay, we just had to give her bad news on that. She had other claims, and we were able to help her and eventually got that resolved because we used it as leverage. But the fact is, on that particular issue, she didn't have one because her incredible nose and her incredible sensitivities are subjective, not objective. So it wouldn't have helped in a nuisance claim. So there's that. Thanks for bringing that up. So now let's talk about, now that you know what a private nuisance is, it's a substantial interference that's unreasonable and that has caused you or caused your interference with your quiet enjoyment of your property. That's the private nuisance. So what are the most common ones? Well, today we're handling one of them. Actually, we're going to handle three of them. But the most common thing that we hear when we get letters or emails on our contact form on the website, people submit questions all the time. One of the most common neighbor-to-neighbor dispute issues that arise that fall into the nuisance category is noise. And noise can be a million things. It could be this person parties every night, or he's in a garage band and we live in a condominium and they're practicing from 10 to midnight every day, the drummer and the bassist and the trumpeter and whatever. Mm-hmm. It could be that. It could be that the neighbor has a really old air conditioning system that has an incredibly loud hum, or it's not working properly. So it's got this click and it's just consistent and constant. Or noise could be, they're not supposed to have hard floors up there, and yet they apparently do, and they're walking around all the time in high heels, and the kids are jumping around, and they're shaking my ceiling, and it's a nightmare. Noise is noise, okay? So loud music, barking dogs, garage bands, loud talking, those are all fit under the rubric of noise.
Trucks, repairs, vibrations,
Right. Right. If the vibrations make noise.
Right, exactly.
Because sometimes vibrations don't make noise. You see, sometimes you get both. Like if somebody's really playing bass really hard, you get those vibrations in a very low noise, which can drive some people mental, including me. I'd go homicidal. It's horrible. So that's what we're talking about. And it could run the gamut, all right? And anybody that's ever had to listen to a dog bark all night, right outside your window, or listen to somebody playing music real loud at 2 a.m, can attest to the fact that it is living hell. Okay? And it very frequently constitutes an actual nuisance, because noise is one of those things that if anything could interfere with somebody's quiet enjoyment of their property, noise is at the top of the list.
Just a brief nugget on that specific example.
And then let's move on.
We had a surgeon come in who lost sleep over dogs constantly barking next door and had to reschedule surgeries. So
but it doesn't have to ever rise to that level.
Right.
It doesn't have to be a surgeon. It could be a teacher.
Yeah.
It could be a plumber. It could be a lawyer. It could be anybody. Everybody has a right to get sleep, and everybody has a right to the quiet enjoyment. Remember, part of that phrase I shared with you at the beginning is quiet enjoyment of your property. Enjoyment's enjoyment.
Yeah.
Quiet enjoyment also. Now, I am being a little bit disingenuous by using that, because that's not really what the word quiet means legally as used in quiet enjoyment, but colloquially, quiet means quiet. So I'm using it that way. Okay? So first thing is, obviously, you want to check your CC&Rs or your rules, your governing documents, to determine whether or not you have any noise-related rules. For example, a lot of HOAs have quiet times.
Yeah.
A lot of HOAs have times where the gardener can start work with the blowers and not start work. Now, in some cities, for some of the listeners that we have in certain cities, like the city of Los Angeles proper, certain blowers are not even legal anymore. The gas blowers. You got to use the electric blowers and stuff like that. But and a lot of municipalities have municipal laws and regulations and ordinances that say what time truckers can, construction trucks can come in. usually 7 a.m., right? Or what time, gardeners can start with blowers. But look at your governing documents as well, okay? There's often going to be quiet times listed in there. It'll be, loud noise after 10 p.m. In condos, you'll see this. In CC&Rs for connected housing, you'll see this a lot. They almost always contain nuisance clauses, by the way, but we'll get to that in a different episode. But the noise issue is covered by lots of governing documents, especially if you live in multifamily housing like condominiums or townhomes where you have connected and shared walls and ceilings and floors. So look at your governing documents, okay? Because the bottom line is loud noise, when it's regular, it's extremely interfering. And in the case of that doctor, or in the case of somebody that's just not getting any sleep because this dog it's unrelenting barking, it is true hell. And you don't have to live that way. It is actionable and you can take action, okay? Before moving on to odors, I do want to tackle this light pollution issue. It didn't really fit anywhere else, so I'm going to throw it in here, okay? It is much less common an issue. We don't see it nearly as often, but we happen to have a current client that has that very issue. We've also had client in the past who was the cause of that issue, okay? In other words, it was the HOA doing their job for a change, stepping in for another homeowner and seeking to enforce governing documents by trying to discipline our client for light pollution. And the fact is the HOA was right. We were able to convince our client to do the right thing. And that went away very quickly, and that wasn't really an issue. There were other issues that we were able to help with. But on that particular issue, we explained to our client that, look, you're wrong here. There's no good side to this. You're going to lose this if you fight this. So let's give them this, because it'll help you with leverage in other parts of your lawsuit, or in other parts of your demand, your case. So light pollution is any time light unreasonably crosses boundaries and interferes with your sleep or your enjoyment of your property. And one of the quintessential examples when there is a light pollution issue is somebody has a 2,500 candle power, or 2 million candle power light outside the garage, right? And your guest room or in your house happens to be situated, 20 feet from their garage, and that light sneaks in. Even though you have blackout curtains, it sneaks in. Okay, that's unreasonable. Nobody has to have their driveway lit like Fort Knox. It's just not reasonable. Most HOAs, by the way, have something in the CC&Rs or in the rules, and you see this a lot in single-family homes, that say when you should have the lights off. For example, my HOA has something in the rules that says that the porch lights and the lights that decorate your landscaping need to go off by 11 p.m.
Yeah.
Okay. Mm-hmm. So you have them on at sundown and till 11, and then it goes dark. That doesn't mean you can't have a light by the garage or by a camera that's motion activated. That's perfectly okay, and that can be on all the time as long as it's motion activated. But you can't have the light sustained in my community after 11 p.m. Okay. A lot of communities have those in their rules. Light pollution could also be something that's being done intentionally to harass you, where people will point a light, a very bright light, a spotlight, directly into your home or your window. We see that.
We see that all the time.
Yeah, not all the time, but often enough to be a problem.
Well, I say all the time because I encounter that quite a bit at consultations with potential clients.
Got it. Okay. We don't always take clients when they come in. So that is also an element of light pollution, and you might have heard that term, light pollution. And you know what? Sometimes you want to enjoy the nighttime, and you don't want to have bright light everywhere. And so if that's coming up in your situation, then that could be a nuisance depending on the nature of the light and how sustained it is and whether or not it's unreasonable. Yeah. Again, based on reasonableness, the objective standard. Always keep that in mind. So after noise, of course, we have light as a minor issue, but the next issue, the second most common issue, is odors. Mm-hmm. Okay? Now, they are harder to prove, but they are absolutely actionable. Now, odors can include or come from a variety of different sources. Got any in mind?
Well, the one that just jumps out to me most recently is a meth lab. Illicit activity. I mean, that's more extreme, but the common ones are...
Well, let's go with meth lab. We actually had a client who living in a very upscale neighborhood, And apparently the 19-year-old, adult, but teenage son was cooking meth. And apparently that smells. Or it has associated smells with it.
I fortunately never encountered it personally, but the way it's described, I mean, it's very, palpable.
And it's problematic, and it can be very dangerous. By the way, I'm not even talking about the explosive. We've all seen Breaking Bad. The potential for fire and explosion and mayhem and death that comes from a meth lab. That's a separate issue. That's a nuisance too, by the way. They're running a meth lab. It's illegal. That's a nuisance. It's also the threat of explosion is very real. That's a nuisance because, the threat of dying every day is something that would tend to interfere with a reasonable person's quiet enjoyment of their property. But we're not on that. We're on that odor. But we actually had one of those in our office, which is strange. But so he came up with meth lab.
But machinery, gasoline.
Right. So let's talk about machinery and gasoline then. Okay. You have a hobbyist next door who works on the car in the garage because a lot of HOAs say you can't do it on the driveway. Or you can't do it in the street or in our community, but you can do it in your garage with the door closed. But let's say they work a lot with gasoline or other chemicals. If the smell is palpable and around enough, if it's common enough, where it's always there or it's too frequently there, then that would be a nuisance. That would be an odor nuisance. Pet waste, you get that a lot.
Yeah.
If somebody doesn't empty their trash can and they're constantly putting the trash bags from their dog, and it just sits and festers in the heat in the summer and becomes a stink, then pet waste can be a nuisance. We see a lot with tobacco and marijuana, smoking. Some HOAs have either elements in their or provisions of their CC&Rs or their rules that ban smoking entirely, which is legal in California. An HOA can ban smoking entirely, even in your own private home. They can do it if they want. Okay, if it's in there, it's enforceable. But a lot of them that don't go that far do have them that say no smoking in the common areas, no smoking on balconies. If you want to smoke, smoke in your unit or in designated areas. Okay, but some will go halfway, but not ban it entirely. So that's what we're talking about. We're talking about the tobacco smoke. If somebody's smoking, if you're in a condo and it's an old conversion and it shares vent space, you might be getting smoke in from a vent because it's traveling from a unit 3 units over here or up above, and it's just kind of making its way around the building. That could be a nuisance. And I lump tobacco and marijuana the same thing because they're both smoke coming from, combustion. Strong cooking odors. If a person, is from a different culture and cooks dinner every night and it creates strong odors, probably not actionable at all. But if they're running, let's say, they're running a private commercial kitchen in their home. So
catering business.
Right. They're running which by the way,
quite a bit.
Would be a home business and probably I don't think HOA could ban that unless clients are coming. But if they just cook in their kitchen and then they're the ones that leave and bring food elsewhere, they probably couldn't stop that. But if the odor is all the time, if they're always cooking, or it's nonstop, that could rise to the level of a nuisance. As I said, much harder to prove, because you can't get a recorder out and record the noise and the dog barking. Here, there are devices you can get. You can have an expert come with a device that I'll call the smellometer, and it actually registers odors and puts a mathematical number on them as a threshold. So there are ways to do it, but it's not easy, which is why I said harder to prove. He mentioned gasoline and chemicals and those sorts of things, hobbyists, let's say. And then, of course, he also mentioned odors that come from illegal activities. Cooking meth is one of those that comes to mind. And then, of course, there's garbage. Okay? If a neighbor got a little mini dump in their backyard and is not taking care of refuse in a way that a responsible homeowner should, and it starts to stink or attract vermin, that is a nuisance. And that kind of odor, you don't have to live with that. That's one that is very actionable pretty quickly. Okay? So we've kind of touched on the 3 big nuisances I wanted to talk about today. Okay? Let's talk about legal strategies. And let's talk about, before we do that, let's touch on what the difference is between a permanent and a continuing nuisance. And then we can talk about legal strategy regarding those. So every nuisance we talked about today falls into one of those 2 categories. It's either a permanent nuisance or it's a continuing nuisance. Because if it's just a one-off thing, like somebody was cooking for a birthday party and it was really bad odors that day, that won't even qualify as a nuisance. So it doesn't fall into either category. Okay? So a permanent nuisance is one that's built into the property in a way. Okay? It cannot be easily changed, or it's impossible to change. Think of a structure that's blocking a protected view. So let's say your governing documents give you a protected view corridor to something, and somebody puts something permanent up and blocks that view. That would qualify as what's called a permanent nuisance. Okay? Because it's not easy to remove. Yeah, they could demolish it, but that is a very big step, right? So it's not easy to remove. It's not easy to fix. It's got more permanence. So that would be considered a permanent nuisance. Okay? A continuing nuisance is one that happens over and over and over again. Okay? It can be stopped, but it hasn't stopped. Noise, odors are generally, almost always, continuing nuisances, although I can think of a couple of scenarios where a noise, for example, would be part of a permanent nuisance. And that is if you have a built-in structure or something that's causing the noise, then it could be a permanent nuisance. But most of the time, when we talk about noise, it's those other things that we were talking about. And so it qualifies as a continuing nuisance. So here's the thing, though. If you're dealing with a permanent nuisance, the statute of limitations, by the way, is only 3 years. And you get money damages only. You would have to prove your damages. And the measure of that damage is the diminution in value of your property. So what's your fair market value of your property? And what would it be without that noise? Because there is a definite hit when you've got to disclose things to potential buyers. By law, you have rules of disclosure. They're not going to pay fair market value if they have to deal with something like that. So your damages are, at a minimum, the diminution in value. Okay? What you're not entitled to in a permanent nuisance is injunctive relief. That means you can't get an order from the court saying, take that out or put it away. Now, I don't want you to get confused because we are, as I told you at the beginning, it's a very complicated subject and it touches on a lot of other causes of action and claims. If, in our example, I use somebody built a structure that blocked a view corridor that was protected by your HOA, the HOA could order them to remove that, and they could sue to enforce that. You could order them to remove it and sue to enforce it. But it wouldn't be under nuisance. It would be under breach of governing documents. Yeah. So when we're talking purely about a nuisance claim, a permanent nuisance, a measure of damages, would not include injunctive relief. Although you came to us, we would include other causes of action where injunctive relief would get you where you want to go. So I just wanted to point that out. A continuing nuisance is you can get damages if you can prove damages, okay? But the big issue for a continuing nuisance is you can get injunctive relief. And that means you can get the court to order them to stop, whatever it is. You are no longer, court order, you're no longer allowed to play in your band after 10 o'clock at night, ever. And if they do in the future, they're in contempt of court, okay? That's a big one. And to make this next point, let me go back for a second. Let me go back, okay? When we're talking about a permanent nuisance, you're entitled to those damages only, and that could be the diminution value, but you can also get what's called future damages, okay? And you're going to have to select whichever one's more, but future damages are, how am I going to be damaged? Because this is not something that can be remedied, so I'm going to have to live with this, okay? And the court, there are experts out there that can calculate the measure of that damage and come up with a figure. So losses or expenses that you anticipate would result because in the future this will still happen, whatever this is, that's future damages. And I apologize for forgetting to mention that. And the reason that comes into play is that's not something you can ever get with a continuing nuisance. Yeah. You can't get future damages on a continuing nuisance. And the statute of limitations, remember, on permanent it's 3 years, but on a continuing, it restarts every time the thing is done again. Okay? And so your damages could include injunctive. It could include money damages, but only for the 3-year statute. So you can only go back 3 years.
Right.
But you can never get future damages on a continuing nuisance. Okay? So that's, in simple terms, that's the basics. Have I missed anything? Anything you want to add?
Just briefly, we every now and then get clients or potential clients who arbitrarily want to attach some kind of a damages element,
Good.
And it's just a arbitrary number. But like you alluded to, we need expert input, and it's also very fact sensitive. So I will refer back to a previous episode. It's highly important that these things get documented, because oftentimes it comes down to facts we can establish and substantiate to justify those damage claims.
And I know I'm rushing because we're going to run out of time, but you're absolutely right. These episodes when we give, and I think is one of my shorts, one of our 1-minute attorney tips, but. And you should check those out. They're 90 seconds long or so, and they are extremely helpful in the real world, real life, it's happening now kind of things. In a continuing nuisance, one of the more important ways to prove it is to document. Keep recordings. If it's a noise thing, you keep recordings. You log stuff. Party went till 2 a.m. on this date. Party went till 1 a.m. on this date. I'm smelling benzene. Today, all day for 6 hours, I smelled benzene. And then another time, I smelled benzene today for 3 hours between this and this. Document everything. That helps you establish the essence of continuing nuisance. Remember those 3 elements that we talked about before. Okay. Now that we've kind of covered, though, the difference between a permanent and continuing nuisance, let's talk about documenting, which is where you were going. Okay. And then we're going to just do it shortly because you kind of covered it already. And that is, judges want to see this documentation. They don't want to have she said, he said conversations with you. Okay. That's not going to help you. You got to imagine that everything you say they did, they will deny under oath and not lose a wink of sleep. You've got to go into it assuming that. So you have to come in with something more than, here's what happened. And part of that is documentation. It's a lot harder to argue with somebody when they've got a written log. Okay? Because, could you the night before make up a log? Sure you could, but most people don't. And judges look at the world that way. Juries look at the world that way. So by documenting, you take it out of the realm of he said, she said. Okay? So start a nuisance log. Call it whatever you want. Document date, time, and the offense. This is noise. This is smells. Whatever it is. You might have a neighbor that engages in multiple forms of nuisance. Typically, a jerk in one area is going to be a jerk in another. Document. Okay? Use video recording. Now, keep in mind, I have a short on this as well, on security cameras. As long as your video is taking your property or common area, yours and part of the common area, you're going to be okay. What it can't do is focus in on somebody else's private property, not their yard, not their homes. If that's where your video is pointing, it shouldn't be, and you could actually be on the hook for damages for interference or for invasion of privacy, which is also a statutory and a common law wrong, a tort. So use video recordings as long as they're appropriate video or audio if you're not violating California's 2-party rule. You can audio tape any conversation with anybody as long as you make them aware that they're being audio taped, or it's so obvious that they don't have to be made aware. For example, if you have a video camera up or you have your phone and I'm taping you or I'm filming you, that usually includes audio. That's enough to get over that. But that sort of evidence is golden, okay? Talk to your neighbors. Try that first. Most people do, but some don't even try.
No.
You never know. Your neighbor might have no idea that they're being as loud as they're being. Now, between you and me, I find that ridiculous because if I'm in a condominium on the 3rd floor and I've got my band over at 10 o'clock and we're playing drums, I have to be an idiot not to know that it's going to leak through the floor to the 2nd floor neighbor downstairs. But go and talk to them first, okay? Try nicely, see what happens. Judges want to see that you made an effort. You don't have to put yourself in danger, and you certainly don't have to try every time it happens. Once or twice is sufficient, okay? Check your city codes. Check your governing documents, because I covered this in another short. If they are violating your HOA's nuisance provision, which 99% of CC&Rs or rules contain nuisance provisions, okay, then the HOA is obligated to enforce. They have to step in, even though they'll tell you they're not. The board will say this is between you and your neighbor. Nah, that's wrong, okay? So check your codes and check your HOA documents. And lastly, don't wait. If you ignore a nuisance for 6 months or a year, and then suddenly it becomes something you can't live with and nothing's changed, that's going to weaken your case. It doesn't negate your right to bring the case. You're not going to get out on a demur as you would if you were to miss the or if you were to miss the statute of limitations. But you certainly are the question will be asked at some point. You lived here for 3 years. Neighbor's been doing whatever this conduct is for 3 years. Nothing's changed, and yet you only complained about it after 2 years. Why? Mm-hmm. That's something you're going to have to get over. Doesn't mean you can't. There might be a reason, but it makes your life harder. So don't wait. If something is interfering, then act on it. Okay? So what doesn't count as a nuisance? Let me give you some very brief tips on this. Okay? These are things that will never count as a nuisance, even though technically they might qualify. And I'm saying this because I'm speaking broadly in public policy. When I advise clients, and I know Sam does this, I've sat in on some of his consultations, and I've seen him do this all the time. When we advise clients, we tell them what the law is, and we apply the facts to the law, but we also go further than that. We say, now look, technically, you're correct. Under the statute, this is illegal. And you've got real damages. You're sleeping 3 hours a night, and you're suffering physically for it, okay? However, in the real world, here's how this will play out. And that's kind of, we do that because we don't live in an ivory tower academic situation like we did in law school, when every problem was based entirely on case law and statute, and you never had to have an inkling of how the real world worked. You operated in this insular world. But in real life, it's not like that. And so here's what I'm talking about. A dog that barks once or twice a week, because let's say you have a stay-at-home mom who's home all day, but on weekends, the family goes out for the weekend, right? So the dog barks a few hours on Saturday and Sunday of every week. Is that enough to constitute a nuisance? It depends how pervasive the barking is. But if it's like, let's say, once a week, no, you're not going to win that, even though it's annoying as hell when it happens. Okay, but that's a weak one. Let me give you a better example. Let's talk about kids and babies. Baby crying. Newborn baby. You live in connected housing. You're in a condo. People above you have a newborn baby. Baby wakes up every single night and cries like clockwork at 1 a.m. and keeps you up for an hour. Or the parents are practicing whatever that method is and letting the baby cry it out, and then whatever. I think that's the Thurber technique. Yeah, whatever. Okay, you're never going to win that. It's not. I would advise you not even to try. You might go talk to them, but you're not going to gain friends, and you're not going to win any lawsuit. Babies cry. That's what babies do. They don't have another method of communication. There is no solution for it, and nobody's going to hold new parents responsible for their baby crying. It just won't happen. Not in the real world. Let's talk about kids again. Kids run around. Kids play during playtime, right? In the daytime. They come home from school, they run around. If you're living in a multi-family, dwelling, and you've got neighbors above you, and clip, 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 clip of the little kid's feet every afternoon for 2 hours, 3 hours, probably not enough, unless they're in violation of the governing documents and they have a hardwood floor and not supposed to. A lot of HOAs say you've got to have a certain level of noise canceling protection in your technology, or you have to have rugs for that very reason. But you can't stop kids from making noise if it's reasonable. Now, if the kid's screaming, older than a baby, screaming at all hours of the night, having a tantrum, that's different. That could be actionable. Same with kids playing outdoors. They're playing in the street. They're playing field hockey, a couple hours after school every day. And you happen to work from home and you got your window open and it's bugging you. Yeah, you know what? Kids are allowed to play. They don't have to go to the park. They don't have to go to a playground. There's case law on this. Kids are allowed to play. And in fact, HOAs that try to prevent playtimes and kids playing in their yards or in front of their houses have been held unenforceable routinely. Right. Have been held unenforceable.
Or may face discrimination actions.
That's where it's based.
Familial status, yeah.
That's right. Mm-hmm. It's based on discrimination. Right. It's just not going to fly, okay? Cigarette smoke. If a person smokes once in a while, like once a week or once a month, you could get them in trouble with the HOA if it's one of the rules, but you're not going to get a nuisance action. It's not frequent enough. It's not deemed to be, it's not a reasonable person. It would not affect their ability to enjoy the quiet enjoyment of their property, because that's an objective standard that applies for all times.
The way this practically plays out is the occasional guest comes over,
Exactly.
smokes.
Perfect. Thank you. That was even better than my example. A guest comes over once every few months. A guest comes over and it happens to be a smoker. Yeah. You're not going to get anywhere. Okay. I think that's all that I could say on this issue. There's probably nuances I could give, but that's good for today. For next time, in episode 2 of our 6-part series, we're going to talk about one of the most common and misunderstood sources of real, expensive, and frequent conflict between neighbors, and that is tree disputes. What are your rights if a neighbor's roots are coming under, destroying your wall, or creeping underneath and getting into your pool and cracking your pool plaster? We see that all the time. Okay, what are your rights when a tree is overhanging onto your property and drops so many leaves during whatever season they do that it's clogging up all your drains, and your landscaper's telling you, look, I got to flush these drains 3 times more in the spring than I do, or in the fall than I do in the spring, and it's costing you real money. What are your rights if a neighbor comes onto your property because one of your trees is causing problems on their property and they cut your tree down, or they cut your branches? That's what we're going to cover next time in episode 2. Until then, have a wonderful day. If you like this podcast, please remember to hit the like button and subscribe. And if you have any questions, feel free to leave a comment. And until next time, have a wonderful day.